everyone, today we are going to talk about copyright protection in Turkey. Copyright is basically a legal term used to illustrate the rights that creators have over their literary and artistic works. Works, which are the subject of copyright protection, are mostly not found in legislations around the world. In Turkish law, copyright protection is regulated within the Code of Intellectual and Artistic Works. Works covered in the code benefit from copyright protection, commencing from the moment of creation. There is no need or requirement to register the work before an official authority. Likewise, the relevant work is not required to be certified. However, Turkish law allows some legal actions to be taken, specifically for providing a convenience facilitating the determination of right ownership over the work. The copyright owner may register his rights at his own discretion. The registration of copyright is a procedure based upon declaration and does not function as an establisher of copyright. It is not possible for the ideas to be registered within this method. However, ideas must be embodied in a form of work that is covered by copyright to be registered. The application for the registration of a copyright must be submitted to the Directorate General of Copyrights under the Ministry of Culture and Tourism. The copyright owner may also follow a procedure before a notary public. Neither of the documents provided grant rights to the copyright owner, but rather function as a proof of existence of copyright. The copyright owned by the author of a work is effective on the whole work and all parts. In this respect, the author can practice his copyright depending on his own wish and will, in matters pertaining to both the whole work and parts of it. The most essential right of the author within the scope of copyright is the right to determine the style of the work. The other rights are to decide whether a work shall be publicized and the date of publication if the work is going to be published. The author of a work has also the right to prohibit the publication of his work by any means in advance. When a work is to be publicized, the author has the right to determine the title as well as the name of the work. In addition, the name or the sign of the author must be shown on the copies of the work if the relevant work is a piece of fine art. If the original version of the work is in the lawful possession of a third party, the author has the right to request to utilize the original version for a temporary period of time. The author also has financial rights in connection with the copyright. These rights are the right of adaptation, the right to reproduce a work, the right of distribution, the right to exploit a work by performing it, and lastly, the exclusive right to communicate the original version of a work or its copies to public by way of broadcasting through organizations. Copyright is protected during the lifetime of the author and for 70 years, commencing from the date of death of the owner. In case of a copyright infringement, the author can request the court to detect whether the action in question infringed the relevant copyright. The author may also request an interlocutory injunction to prevent the infringement of the copyright. In addition to these claims, the author can also request to be indemnified for the pecuniary loss and intangible damages.